What I want to talk to you about today is the experience of getting a case into the Supreme Court and then arguing in front of the Supreme Court. This was back in 2009, 2010 for me. We're necessarily going to talk some about the specifics of the case, which was rather technical and involved the statutory interpretation of federal jurisdiction. So I know that doesn't sound like the most exciting thing in the world. Some of the analysis and some of the issues that came up about it and some of what the judges had to say may remind you a bit of the rabbis parsing the meaning of the Torah. So in that sense, it sort of fits with our group in particular. But I'm going to try to emphasize the experience and the process as much as I can, although we still obviously need to talk about the specifics or it won't make much sense. If you want to ask questions, please just ask questions as we go along. If you're not asking questions, please have yourself on mute. So for me, this started one day when a lawyer named Mike Lang, who at that time officed with my firm, came in and asked me to take a look at a decision that he had just gotten from the Seventh Circuit Court of Appeals. The Federal Court of Appeals is the appellate federal court that's above the trial courts, the district courts, and below the Supreme Court. The only court above them is the Supreme Court. And this case involved it was in the context of immigration. There was an Albanian named Agron Kukana who had come to this country on a visa and then applied for political asylum. Unfortunately for him, on the day of his hearing, he didn't show up. He explained later that he overslept. So his petition for asylum was denied. He then made a motion to reopen this before the immigration judge, which was denied. He then later brought a second motion to reopen in front of the body that's above the immigration judge, the Board of Immigration, or BIA. And at this point, he was saying the conditions in Albania had gotten worse than when the process started. And this was a valid basis for overturning the prior decision and getting asylum, political asylum. He explained that as a supporter of democracy and free markets, he was now in danger of being beaten or even murdered if he went back to the country because of changes in who was in power, despite Albania saying it was now a democracy. But that motion was denied by the Board of Immigration, and his recourse now was to appeal to the Federal Court of Appeals, which he did. It happened to be in the Seventh Circuit, which covers Illinois, Wisconsin, and Indiana. And when this was presented for argument in the Seventh Circuit, with the Justice Department representing the government and private attorneys representing Kukana, the judges raised the question of whether they really had jurisdiction, which we're going to get into in a minute. They then decided, and even though the government was saying, yes, you have jurisdiction, and of course, Kukana was saying you have jurisdiction. In fact, the Seventh Circuit ruling was that they did not have jurisdiction. And this was a weird split where it was when you go before the Federal Court of Appeals, normally you're in front of a 3-judge panel. They split 2-1 in favor of ruling that there was no jurisdiction, but one of those judges who ruled on no jurisdiction said, I'm ruling this way because we had a recent case which requires me to rule this way, but we're wrong and we should change this. This should be heard by the entire Seventh Circuit, which is called a rehearing en banc. But as it was, Kukana lost 2-1 with a dissent. So there was an effort made to have it reheard by all the judges of the Seventh Circuit, which failed, but 4 of those judges dissented and wrote a dissenting opinion. So with the dissenting opinions that I was reading, and I read this over several times because frankly, I don't do immigration. I did not do immigration work. I was completely unfamiliar with the whole system and statutory scheme. But what made sense to me was the dissent saying we have jurisdiction. And so I decided to take the case. Kukana was out of money at this point, which is why his lawyers originally hired Lang to do a piecemeal bit of work, and then it got offered to me. And I'm not patting myself on the back for trying to do social justice, because frankly, I thought it was the best opportunity I'd ever seen to get into the Supreme Court. I had been turned down in a couple of prior petitions because almost all Supreme Court cases are taken as a matter of discretion. And somewhere, I don't know the exact statistic, but it's probably in the high 90 percentile of cases where the Supreme Court is asked to take a case or turned down. To get into the Supreme Court in this way, you file what's called a petition for a writ of certiorari, which is abbreviated to a cert by lawyers to a cert petition. So now I had to write a cert petition. So let me get in for a moment to why did the Seventh Circuit rule the way it did for no jurisdiction? Well, some months earlier, they had made a ruling that if the decision in this context of the Board of Immigration was discretionary, they had no jurisdiction. This was because there was a statute, and this is where I wanted to share the screen with you, but I don't seem to be able to manage that. I'm going to try one more time, so bear with me. Okay, can you see this on the screen now?
Yeah, we got it.
Okay, great.
Yeah.
Great. So this was the key language here in the second section. Matters not subject to judicial review, any other decision or action of the Attorney General, the authority for which is specified under this subchapter to be in the discretion of the Attorney General. So this is the key wording from the statute that they focused on. Now, the specification for the Attorney General's discretion was not literally written in the statute. And of course, the statute comes from Congress, but it was written in a regulation by the Attorney General. So the statute allowed the Attorney General to issue regulations. The Attorney General issued a regulation that said this kind of decision is discretionary. And then the Seventh Circuit said that was good enough to remove jurisdiction. My cert petition concluded, this first part here, given the importance of the procedural safeguard involved, the significance of the
Can you hear?
No. Of the proper approach to interpreting the jurisdiction stripping statute, that's what the statute was referred to as the jurisdiction stripping statute, and the Seventh Circuit's conflict with at least 7 other circuits and the government, and opinions of the Supreme Court, the case merits being heard by the court. So when you're trying to convince the Supreme Court to take your case, you're not focused on whether the decision was correct or incorrect, which would be the intuitive thing one would figure. Instead, you have to focus on the legal significance of the case. There's way too many cases where people are going to tell them it's a bad decision. They have to limit their work to what is very legally significant. So one of the classic ways you do this is to say this decision of, in this case, the Seventh Circuit, is in conflict with other federal courts of appeals around the country, which it was. It was the minority opinion among federal courts of appeals. It was also contrary to the government's position. So you had the government whose self-interest would be to say no jurisdiction, saying we can't in good faith say that, there's jurisdiction. So in essence, I was trying to say to the Supreme Court, the Seventh Circuit added up 2 + 2 and got to 17, and this is really important, you should take it. And it turned out that they agreed with me. As an interesting side note, some very good lawyers from the University of Virginia had the same situation in a separate case. They wrote their own cert petition. It read like a law review article. It was heavily footnoted. It showed great legal scholarship. It was more complicated than mine by far. They got denied and mine got accepted. All I can say is sometimes simpler turns out to be better. So how did I find out that my cert petition was accepted? Because I'm not going on the Supreme Court's website every morning checking this thing. I get to my office one morning and I have a slew of voicemail from national law firms. And they're telling me, congratulations, your cert petition was granted. We're now ready to step in and help you, which actually meant take over. You know, we'll keep you on the briefs, you'll get full credit, and we'll take it from here. Good job. So I had one voicemail from a national law firm that was different than that. It was from, excuse me. It was from a guy named, a lawyer I knew named Dick Campbell, who I actually used to office with when he was partners with one of my present partners now. And Dick had moved on to become a partner at Jenner & Block, which is one of the big firms in Chicago and a national law firm. And Dick's voicemail to me said, got an email from my DC office asking if anybody knew Rick Schoenfield. I already told them, you're not turning the case over to anybody. They said, tell him we'll give him any help that he wants. Well, this is fantastic. I'm more than happy to accept any help that I can ask for from Jenner & Block. So I wind up working with Jenner & Block, which was a terrific experience. They put a mid-level partner, one of their star senior associates, all these people are from DC, on the case. The star senior associate had already successfully argued in the Supreme Court, and then they have 3 or 4 or 5 junior associates ready to go to work. So the way we did this was then, the next step is we file a brief, our written arguments to the Supreme Court. So I would do the first draft, they would then do the second draft, send it back to me, and we'd go back and forth until everybody was happy with the last comma. And that was the process that we went through. Okay, so the main arguments here, let me try to go back to share screen, worked before. Except where'd my document go? All right. All right, so I'll just do it verbally. So the main arguments, the main arguments on our side were that the Seventh Circuit's reading the statute was wrong because the statute said it had to be specified in the statute, and our argument was that that did not mean specified by a regulation. It also in the statute, it said as specified under this subchapter, and the authority for the regulation was from a different subchapter. Our main arguments also included some presumptions, one that was in favor of judicial review, another in general, meaning have jurisdiction, another presumption that actually existed that if something was ambiguous, it should be decided in favor of the alien, meaning the non-citizen, who was trying not to be deported. So we had those presumptions going for us. Also, and this turned out to be significant, we made the argument that this decision is substantively harmful to the system of justice because since the regulation came from the Attorney General, and according to the Seventh Circuit, the effect of the regulation was to remove judicial review, remove the court's jurisdiction to review this case, that was opening the door to the Attorney General issuing regulations and insulating decisions of the executive, because the immigration judges and the Board of Immigration are part of the executive, and they're actually under the Attorney General's purview, like the Justice Department is. We're letting the executive deprive the courts of jurisdiction, and who knows where this may lead to. This is harmful, is what our argument was. Now, because, interestingly enough, because the government actually agreed with us, somebody had to, in effect, argue for the Seventh Circuit. And so what happens in these cases, as I discovered, is the Supreme Court appoints a lawyer to argue for the Court of Appeals. And what they did here, as they normally do, is to appoint a former Supreme Court clerk who had not had an opportunity to argue in the Supreme Court before to represent the Seventh Circuit. And she then got to pick another attorney to help her, what's called the second chair. And she picked a friend of hers who had been a Supreme Court clerk when she'd been a Supreme Court clerk. So on the other side were these two former Supreme Court clerks. So we filed our brief, they filed their brief. We then filed what's called our reply brief. And then we waited for the court to tell us that oral argument was scheduled. So we get the notice that oral argument is scheduled. Now, during this time, between the briefs and the oral argument, I had a luxury that I'd never had before in my career because I've always been with a small firm. And that luxury was doing real practice arguments. Not just going into my partner's office and sitting down and saying, in fact, let me try this out on you, tell me what you think. Or even with a couple of lawyers in my office. But because this was the Supreme Court, between my contacts at Chicago Kent, where I'd been teaching for a long time, teaching negotiations, and Jenner and Block's contacts, we scheduled formal practice oral argument sessions before 3 or 4 or 5 lawyers who really knew about immigration law and federal jurisdiction, first here in Chicago, at Chicago Kent, and then DC, at Georgetown, and at Jenner and Block. By the way, Jenner and Block nicely paid for all the printing. I just paid for my own travel expenses at this point, which seemed fair. So I went to DC, had the practice oral arguments, which were extremely helpful because I can tell you I was doing a much better job after the last one than I did in the first one. So then it came time to do the real oral argument. And what I did was, having never been in the Supreme Court before, I went in a day early. There is this whole Supreme Court culture that you actually get tickets to hand out for the people who are your guest for the court. There's a long line outside the court often to get in if you don't have a ticket. So I got my tickets. I had my guests there. But what I did was I went in a day early, and as a lawyer who had an argument coming up, I automatically got in, and I listened to 2 arguments the day before my argument, which turned out to be cases coming out of Florida about Florida's law at that time, which allowed them to give juveniles a life sentence, treating them as adults for murder. This was helpful to me, partly because I just got what I'll call the feel of the room, just being in there and getting a sense of things and a feel for things. It was also helpful to get a bit of an idea about the style of the judges. I knew a little bit, like everybody knows, everybody who pays attention to these things knows that Justice Thomas rarely does anything but whisper in the Judge Breyer's ear. But what I got, one of the things I got out of being in the day before was that Breyer has a really interesting style. He reminded me of Columbo, because he more or less, and there's a slight exaggeration, went, well, I guess I just don't get it. I must be the only one who doesn't really understand this, but it seems to me, and then he would give a full sound theory of the case and very politely challenge the lawyer in front of him to explain why he was not actually right. Okay. And it turned out it was good that I'd seen this the day before. So that was my preparation. Not to mention a lot of just time on my own, reviewing things, including the night before. The 2 nights before in DC, my first night in DC, I'd had a nice dinner with my family, but that's not the main point here. All right, so that morning in the Supreme Court, the lawyers who are arguing are supposed to, of course, get there early. And one of the things that happens, which doesn't happen in any other court, is someone from the clerk's office takes you back to their office and reviews Supreme Court protocol with you. Because in the Supreme Court, you don't refer to them as a judge. That would be a terribly impolite thing to say. It's Your Honor or Mr. Justice or Ms. Justice, as the case may be. You don't refer to your opposing counsel. That's not polite enough. You refer to my colleague. So they really require, not just emphasize, but they require civility before them, which is a good thing. So I got that review, and then it was time for the oral argument. So I made my introductory sentence, Mr. Chief Justice, and may it please the court. And I was in my second sentence when the questions began, which is how it should be. They don't need to listen to you give a little speech. The point is for there to be a dialogue through questions and answers between the attorneys and the court. By the way, my time was cut in half because I had to share my time with the government, who was being represented at this stage by the Solicitor General's office, which was good for the case, even though not as much fun for me. But there was enough during my time. Excuse me. So Oh, so the first, not the first question, but the first question that was worth mentioning here, as it's sort of unusual and actually problematic question, came from Justice Scalia, who started asking about the statutory authority for the Attorney General to issue this regulation that was important to the case. And his asking about that wasn't the problem. He wanted to know if that statute was in the briefs somewhere, and if so, where? Well, I thought it was in the briefs, but of all the things I was busy memorizing, like about all these immigration statutes, where in the brief this was not among them. And in the second or so that it took me to process this, suppress my annoyance and get ready to say, Your Honor, I'm sorry, I don't know. In that second or so, my second chair, Lindsay Harrison, the Star Jenner and Block senior associate, was sliding our reply brief over to me, open to the correct page with the paragraph underlined, as I more or less smoothly answered the question thanks to her. Okay, so we then went on and Justice Ginsburg then raised the key question that she was really focused on. What she said was, going back to that statutory language which I showed you before, about being specified under this chapter, as she phrased it, the key word that's emphasized in this case is under. If, as she pointed out, if the statutory language had said in this subchapter, we probably wouldn't be there. The Seventh Circuit would have decided the case differently. But did under mean in, or did under mean pursuant to, as the Seventh Circuit decided, and as their attorney, who was officially called an amicus, a friend of the court, were arguing. So from there, of course, I said that it was in, and made the argument that that's what the statutory context meant. And at worst, it was ambiguous, in which case we should win. And and then Scalia did me a favor and said, well, regardless of that, since the authority for the regulation comes from a different subchapter, and your jurisdiction stripping statute specifically says specified in the subchapter, you win anyway. So that was that was the easiest question I was going to get. So I agreed with him. You're absolutely correct, Your Honor. Scalia made things more difficult in a couple of minutes. After Justice Kennedy gave me a hypothetical based upon that I'm not going to really get into because I still don't see how this was extremely relevant. But we talked about his hypothetical for a minute. And then Justice Scalia came back in. And now Justice Scalia said to me, and I quote, "The big obstacle I find with your position is," and he's talking about our main position, that, to go back to Ginsburg's analysis, under means in. The main obstacle that I find with your position is that it doesn't make any sense. Why would Congress want to exercise review for discretionary judgments by the Attorney General that are recited explicitly to be discretionary, want to exclude review exclude review for decisions that are specified by Congress to be discretionary, but allow review for decisions that are not specified by Congress to be discretionary. So he basically said your main argument is wrong and doesn't make any sense. As he was saying, a discretionary is discretionary, and if it's discretionary, it shouldn't be reviewed, which is really the Seventh Circuit's position. He said, why is this even rational? Your main argument. Now, this is not actually such a bad question to get. And the reason it's not a bad question to get is, number one, if this is his thinking, you want to know about it, he's giving me a chance to make my argument as to why his at least supposed thinking at this stage is wrong. He may or may not really strongly believe this. He may be thinking maybe this is right and just be putting it out there to challenge the attorney. So you actually want judges to do this as long as they then give you a chance to respond. If they're just making a speech, it's not helpful. But if they're giving you a chance to respond, this is a good thing. It's sort of like a lawyer, when a lawyer picks a jury, you're hoping that if there's something bad the prospective juror is thinking, they actually tell you about it no matter how bad it is, because if they don't, they might wind up on the jury and then you've got no chance. So he did give me a chance to respond, and I then went into the main arguments from our brief about why, properly interpreted and using the presumptions in our favor, when the statute referred to decisions specified under this subchapter, it meant specified in this subchapter and not meant specified pursuant to this subchapter. I hope this is making sense as I'm going along here. Okay, because if you have questions, please ask. So in part, I said, Congress specified some 10 instances of discretion to the Attorney General in subchapter 2. That was our subchapter. And I believe it drew the line there and said, if we did not specify it in subchapter 2, then it is reviewable, just as courts have traditionally reviewed these matters. And shortly after that, I reserved the rest of my time, which was down to 3 minutes, for rebuttal, because I was going to get the last word of any of the lawyers in this oral argument. So it then moved to the Solicitor General, and during her time, this is where Justice Breyer got into it. And so Breyer says to her, I can't find a reading of this statute that makes sense. Okay, he's got our reading, he's got the Seventh Circuit's reading, and he can't find either reading that's making sense to him. I can't find a reading of this statute that makes sense, except for one which I am trying on. And I'm sure there's a lot wrong with it. That what Congress meant to do here is to take all the procedural decisions, including reopening ones, and treat them the same way that they are treating the substantive decisions. So that in this case, he wins, meaning us, Kukana. Because he gets a review of the substance, he should get a review of the reopening. And in other cases, they lose, because if you don't get a review of the substance, you should not get a review of the opening. Both are the same thing. What he meant was there was other statutory authority that said that a deportation order was reviewable by the Federal Court of Appeals. outside this context of a motion to reopen before the Board of Immigration. So Breyer went on to say, so that to me is the only reading of the statute that I've yet found that made sense, but since no one argues for it, I'm sure I must be making some huge mistake. This is why I said he kind of reminded me of Columbo. Well, I just don't know, but let me turn around and ask you one key question. But that's what you can tell me. So the Solicitor General tried to respond to that. I'm not going to get into exactly, she sort of went around on that and said similar things to what I said about the statutory scheme. But then this came up again in the next portion of the oral argument, where after the Solicitor General, it's now time for the amicus, the attorney appointed by the Supreme Court to argue the Seventh Circuit was correct. So she was up, and Breyer raised the same thing with her. Which I'll get to in a second here. So he brought up the same issue with her, but he started out by saying, do you want to say anything about apparently this idiosyncratic thought that I have had? My thought is that both sides are arguing. We just looked to see if it's discretion given by the statute or given by regulation. And I say we draw the line in a different direction. Do you want to say anything about that? He said, so Congress has one simple judgment. We want courts to meddle in these affairs substantively, or we don't. So I would draw the line horizontally instead of vertically. It was the way he envisioned this. So she said, with respect, Your Honor, I think that no one who agrees with you includes Congress, rejecting his analysis. Which was not likely really to convince him, I thought. She went back to, the word is discretionary. Congress used that word, basically told him he was wrong. So I was going to be getting up again shortly, and it seemed to me that if I could narrow our position down to agree with Breyer's analysis being consistent with our position, that we ought to be able to lock up his vote. So we had been, in the briefs, probably taking a broader view of things, but my job wasn't to take a broader view, the broadest view possible. My job, of course, is to try to win the case. So let me see if share screen will magically work again for me or not. Are we on there?
No.
It says I'm sharing the screen. Okay, all right. Well, it wasn't written anyway, so what All right, let me try to come back to you. Share. All right. All right, here we go. All right, so at this point, as it came back to me, what I got up and began by saying was referencing the statutory section, naming the statutory section. So that section mandates that review of the underlying decision should be consolidated with the review of the motion to reopen, which procedurally fit Breyer's analysis. I think that tells us several things. The first and foremost is Congress intended there to be a review of motions to reopen, at least some. To try to go back to Justice Breyer's questions, I think one can extrapolate from the consolidation provision that if it is impossible to consolidate because there's no review of the underlying decision, you do not get to have a review of those motions to reopen. We did, okay. So I was trying to say that within our argument, Breyer's position fit because he would have said, if you have a right to have the substance heard, should he be reviewed, should he be deported in light of alleged changed country conditions, then you get a review of the reopening. And I then referenced that this was a matter of life and death, potentially, certainly a matter of liberty. When you have new evidence of changed country conditions, and in reference to, again, a prior question and answer in the argument with the lawyer for the Seventh Circuit referring to getting 2 bites at the apple, the second motion to reopen, saying it wasn't 2 bites at the apple, it was the first bite at the apple on the new current conditions. So I then noted that ambiguity was resolved in our favor, and that wrapped it up. And they actually let me talk in the rebuttal without further questions, which was probably a good thing. So so that was the oral argument. Now, I'm trying one last time here on the screen share. Oh, now I've lost you. Here we are. Okay, share screen. Okay. Can you see this now?
Yes.
Okay.
Yes.
So that's my brother and I. My brother and his family were among my guests who had come to hear the oral argument. My brother is also a lawyer. And I will say that I and Jenner and Block were optimistic about our chances. Mark, my brother, said this immediately after the oral argument, and he was the only one to say it. He said, "You're going to win unanimously." And he actually complimented me by saying that my rebuttal had just locked it up. So that's a picture of us in front of the Supreme Court steps and a picture of the cover of the first page of the oral argument and a cover of our brief. The other objects in there are quill pens you may recognize, not that any of us actually date back to colonial times. It turns out that when you argue before the Supreme Court, you get a souvenir quill pen. If you want to buy the inkwell with the ink, you have to go to the souvenir shop, but you get a quill pen. You should only get one, or actually we were getting two, but one had been promised to Mike Lang, the attorney who handed the case over to me, who was also a guest. Lindsay, that second chair I mentioned, grabbed the Solicitor General, one of the Solicitor General's quill pens, saying to me, because she knew I wanted an extra one if I could manage, saying to me, they got plenty, they don't need them. So technically speaking, we walked out with the Solicitor General's quill pen and wound up framing this so you can see the quill pens. It turns out that Mark was correct. We did win 9-0 with Ginsburg writing the opinion. And in the opinion, she agreed with us that under, in the context and with the language here, should be read as being specified in the subchapter, not specified pursuant to the subchapter. She also agreed with us that the presumptions in favor of judicial review weighed in our favor. She actually footnoted, without mentioning Justice Breyer, footnoted his analysis and in the footnote said, this may be correct, but we don't have to decide it in this case, so we're not going to decide it, which I'm sure satisfied Breyer. And at the end, she emphasized the last point, that it would be bad policy here to allow the executive branch to issue a regulation which had the effect of depriving the judicial branch of being able to review a case. And what she said was, if the Seventh Circuit's construction of the statute were to prevail, the executive would have a free hand to shelter its own decisions from abuse of discretion, which is the standard for discretion, abuse of discretion, appellate court review, simply by issuing a regulation declaring those decisions discretionary. Such an extraordinary delegation of authority cannot be extracted from the statute Congress enacted. While none of us envisioned today's situation, I will rhetorically ask you, can you imagine if Bill Barr could deprive the courts of jurisdiction by issuing regulations, where things would be? At least in the immigration context, where he would have that ability. So the case was important because it really made a difference on allowing people who are in danger of being deported the right to this review or not. I think it's fair to say that these days it's taken on even more significance. It turns out that my client, after he got the review, still lost, but I didn't represent him there. I'm not saying I could have won, just saying I didn't represent him there. I'd only taken on the Supreme Court aspect of this. They basically didn't accept his argument about conditions being worse, as he was arguing. But the case was about setting a precedent for everyone except the client, who obviously he cared the most about, did he get to stay? It did buy him several more years here or there, though, so that was worth something, I would think. So happy to answer any questions if anybody has any.
Yes, did sleeping late kill his chances, or did that never?
I think it might have killed his chances with the Board of Immigration. I doubt it killed his chances with the Seventh Circuit. It didn't help him any. It should have been irrelevant. There was a factual question, though, about the country conditions. Kukana had a professor who was a legitimate expert in Albania supporting his position. The government was saying otherwise. So that was a tough argument for him to win on abuse of discretion.
So Rick, how long were you before the Supreme Court? How long was your presentation and the back and forth?
Oh, the whole thing was scheduled for an hour, but it went longer than that because they can do whatever they want to do, of course. Well, Justice Roberts can run it as he pleases. So my part of this was probably in the 20, 25-minute range, I'm guessing. At the time, I was very conscious of time when I was up there because I had to make sure that I saved time for rebuttal. Otherwise, I'm not allowed to get that last word in. So at this stage, I'm guessing it was in the 20-minute range because I think we did go over.
This probably sounds like a stupid question, but is there a clock? Or if you want to watch time, do you have to be looking at your watch or something?
No, on the podium that you're behind, they're showing you the time.
Okay.
You don't have to look up at a clock, much less look at your watch. They're giving you the time.
All right.
Yeah. In the Seventh Circuit, there are lights on their podiums. There's a warning light, and then there's a you're out of time light.
Okay. Interesting. Wow.
One experience that definitely also had helped me, though, was I had once argued a case in front of the entire Seventh Circuit on a rehearing en banc, in front of all 9 of them. So at least I'd been in front of a court that was numerically that large before. And I thought that might be the only experience I had like that. And that was turned out to be a very memorable argument, that particular one, which was from for me, more straightforward on the legal issues, civil rights case of police misconduct.
Did any of the justices fall asleep?
No, they were actually pretty engaged. All of them except Thomas asked at least one question, and Ginsburg and Roberts and Kennedy, and of course Scalia and Breyer were really very engaged in it. Lawyers can find these kinds of issues interesting. Like I said at the beginning, in some ways it reminds me of some of the rabbinical interpretations and searching for interpretations of Torah or Talmud. What was really meant here?
Yeah. It seems hard to believe that it kind of hung on whether the word was what in meant, in or under. I mean, it's amazing to me.
Yes, I mean, I actually thought that that second argument I referred to about how it said specified in this subchapter, as Scalia said early on, was okay. We win anyway. You know, we need to make our main argument that this is what it should mean. This is what the statute was intended to mean. But even if we're off, they're relying on something in the wrong subchapter. But yes, that's how it turned out that's what it was. That was the most important issue, as Ginsburg brought up in the oral argument, and then, excuse me, and then she wrote the opinion. There was one concurring opinion by Alito, which said we should just decide it on the subchapter issue. We don't need to get into any of these other things. And I don't necessarily agree with these other things, but the other 8 of them just joined in. The other 7 joined in with Ginsburg.
I may have missed this, but from the time you finished your arguments to the time you knew what their position was, how much time transpired?
It was relatively quickly. It was actually only about 2 months, which is fast.
Oh, okay.
So we argued in November and got a decision in January.
Well, thank you very much, Rick. I appreciate you doing this for Lunch and Learn, and I appreciate everyone showing up.
Great.
And
Yeah, it's
maybe I'll
very
go back to
interesting.
school now and become a lawyer.
Yeah, we enjoyed it.
Good. Oh, good.
Oh, yes.
There's
Thank you so
fun for
much.
me.
Thank you
Rick.
very, very much.
Thanks for
Thank
coming.
you.
Yeah,
All right,
it's a
thanks,
real accomplishment. It really is.
It is.
Thanks.
It's an achievement.
Thank you.
Bye.
Okay.
Bye-bye.
Yeah,
Bye,
thanks for
everybody.
sharing,
Have a
Rick.
good
Bye.
day. Bye.
Bye.
Rick.